Mr. Gaynor?
May it please the Court, my name is Martin Gaynor. I represent the plaintiff appellant in this matter, the A.W. Chesterton Company.
Mr. Gaynor, let me just say at the outset that we have received a letter concerning the appropriateness of certain amicus filing briefs, and the Court does not consider amicus briefs that don't comply with the rules, so that you don't have to dwell on that point.
Thank you, Your Honor. That being said, I have two issues that I would like to discuss this morning. The first is whether the Superior Court erred when it included in its declaratory judgment a statement that the fund is not obligated to make any indemnity payments to Chesterton unless and until Chesterton exhausts the limits of all applicable solvent coverages.
Can I just ask you a couple of quick things?
Yes, Justice.
Just for my own edification, maybe it appeared in the briefs. If it did, I missed it. How is the fund created? Is it by contributions of other insurers?
That's how it receives money every year. It sends out bills to all the insurers that do business in the Commonwealth.
Okay. If in fact, and I know if we accept the fund's argument and find that the judge's findings as to the first three Midland policies are wrong, clearly erroneous, and that as to the fourth he's correct, then the case is finished, isn't it?
That is correct.
Because there is no, quote, excess insurance to be argued over anymore. The policies are void.
That is
right?
correct.
Okay. Now, the point you're getting to address, the all sums rule, I think it's called in shorthand, was that actually litigated?
It's not really the all sums rule. I think there is an issue in these cases on how to, when you have an injury or claim that spans a long period of time, such as asbestos claims, which is what we're dealing with here.
Right.
You have multiple successive liability policies that may answer for those claims.
Right.
Say you have 10. There is lots of case law throughout the country on how you go about allocating how much each one of those policies is responsible for paying. There are different varieties, but it basically boils down to two major theories. There's the joint and several or all sums approach and the pro rata approach. This is actually the issue that the
amicus
various, put in.
Right. But the judge
it was, in fact, litigated in this case.
It was?
It was.
Okay.
And Chesterton, the reason it's not here before Your Honors is because Chesterton in the Mass Insolvency Fund took the same position. We both took the position that the appropriate allocation method was all sums, joint and several. The defendant insurance companies that were in the case argued in favor of the pro rata theory, and the Superior Court rejected that view and adopted all sums.
But they're not in front of us, are they?
That's correct. That was
the point of the letter.
That was the point of the letter.
That's the point of the letter. So
yes.
We can narrow this case in that regard. These amicus positions are off the table.
That's right, with the exception of one. Boston Gas submitted an amicus brief, they put in a section on the issue that Your Honors said you're not going to address. But they also did address the issue that you sought amicus briefs for, which is this quote-unquote exhaustion that applies to the fund.
Right.
And I would invite Your Honors to look at page 3827 of the appendix, and there you will find a coverage, what's called a coverage chart, that shows graphically the different insurance policies that we're talking about. One thing I would say about that is that chart is a version that does not reflect several policies that were in place prior to 1968 that the Superior Court found to exist based on secondary evidence. Other than that, that chart accurately reflects the policies that are at issue here. And by looking at that, it helps to explain what's really going on here. Essentially, the exhaustion, quote-unquote, position that the fund is taking is that the fund is standing in the shoes of the Midland Insurance Company. Midland issued 4 policies between 1980 and 1983. Those were all issued on the first umbrella excess layer. The fund's position is that essentially all other coverages in that block of coverage that you will see at all different layers with the possible exception of the policies that sit directly above the Midland policies, must be exhausted prior to the time that Chesterton can go to the fund to recover obligations
And when you
related to
say
the Midland.
exhausted, you mean paid and pay out everything?
That's why we're here, to figure out what we mean by exhaustion. That was an issue that was not actually presented to the Superior Court below. In the Superior Court, what happened was the defendant insurers, who are not before you, took the position that there was no exhaustion requirement at all, meaning that Chesterton did not have to go to these higher level policies before going to the fund. And they argued that because they wanted the fund to respond at the same time they did. The defendant insurers in that case were the other insurance companies on that first umbrella excess layer. Chesterton took the position that, based on the all sums finding, that all these other carriers would have to respond to basically all of these claims. And given the complex factual background surrounding all these underlying claims, there are literally hundreds of thousands of these, that it was appropriate to have some kind of exhaustion requirement to reflect the policy that's reflected in many of this Court's cases and the appeals court cases, that the fund is to serve as a source of last resort. However, no one presented, neither Chesterton nor the fund, presented to the Court the issue of what showing of exhaustion does Chesterton actually have to make when it gets to the point of having gone through these other insurance policies. And that's really what we're talking about in this first issue. So in a certain sense, it's unusual it's before the Court because it really wasn't argued below. But the reason that – I'm sorry, Your Honor.
Finish your sentence and then I'll ask
The reason that we are here is because when the judge issued his decision, he inserted the word limits in the declaration concerning exhaustion.
Why didn't you go back then before the judge for to argue before him for clarification of the issue of what exhaustion means?
I did, Your Honor. And you will find in the record I filed a motion to amend the judgment to clarify that issue. And the judge denied it without a hearing, and that was that. So we didn't have an opportunity to actually argue it, but it is in the record appendix. So the issue...
So the judge did rule. He did say you got to exhaust the limits of all available policies. Limits means limits.
By denying that motion, right, one could infer that if that is, and the question is, what does it mean?
Exhaust, at least in his mind, means the whole policy.
So to the extent that that is what that decision means, then Chesterton submits that that is error for the following reason.
What else could it mean?
It could mean that if Chesterton reaches a good faith settlement with
yes.
any of those carriers,
Yes.
then that good faith settlement constitutes exhaustion. And that is the only workable scheme that can exist, because otherwise...
Why is that the only workable scheme?
Because otherwise, Chesterton, it would be impossible for Chesterton to settle with any of these other excess carriers.
You've got to litigate every case.
Because they would have to get 100 cents on the dollar, and as I'm sure Your Honors know,
so they would
that is a
litigate,
difficult
maybe
proposition.
litigate every case, maybe they wouldn't, maybe the insurance companies would say take the policy, we're stuck. If it's a good faith settlement, who determines what's good faith? Aren't you back in court on that?
We might be, Your Honor.
The fund's
I
going to
think-
say that wasn't in good faith. They just wanted to get the thing over with. The insurance company wanted to save money, stick it to the fund. We're going to go in and litigate this good faith. So you're in court no matter what.
They might not. If Chesterton, first of all, you have to remember that Chesterton has all these policies and needs these policies in order to fund this huge asbestos liability. Mm-hmm. It is in Chesterton's interest to get every cent it possibly can out of these policies. To the extent that the fund ever became of the opinion that there was any type of collusion or bad faith in the settlement, they would be entitled to try to prove that when Chesterton went to the fund and said, we have now settled with all these carriers, we have recovered good faith settlements from all of them, we have used those good faith settlement dollars to pay asbestos claimants and related defense costs, and now it is time for the fund to respond to the Midland obligations.
Wouldn't the good faith rule also lead to higher premiums for
Higher premiums for whom?
people buying this excess insurance? I mean, tell me if this hypothesis is wrong. We accept the good faith, settlements are made, the fund therefore has to respond to, hypothetically, the difference between the settlements and what's paid out. The fund says, okay, we need more money from insurers to fund it every year, because of last year, all the money we paid out on these asbestos claims, we need all these millions of dollars from you guys. They say, okay, we'll pay that in, we'll raise the premiums.
That doesn't really increase the burden on the fund or on any taxpayers for the following reason. The fund's obligations are capped by their statutory cap of $300,000, and they're capped by the limits of the Midland policies themselves. All we're talking about here are two factors: timing, when does the fund have to respond, and two, and more importantly, does the fund ever have to respond? What's really happening here is that the fund is trying to extinguish at this very moment all of its obligations. And you can see that if you look at their brief, where what they asked this court for is a credit equal to the amount of all the solvent limits. Well, if you look at the coverage chart and you add up, it has the limits stated in there, you add those numbers up, that exceeds the total amount that Midland issued, even if you include the policy that lower court voided. And as a result, that credit would extinguish all of their obligations.
Well,
there is no, I'm sorry.
No, go ahead.
There's no reason in logic or law or anywhere else to get to that result.
If you're right, then do the primary carriers, are the primary carriers now out of the picture without having paid full policy limits?
No. Your Honor, that was, and if you look at the coverage chart again at 3827, you'll see all of the primary carrier policies have been exhausted. That was the primary issue in phase one of the trial below. Did Chesterton properly exhaust all those primary policies? And the court decided yes.
Exhausted in the sense that paid to the limit, or exhausted in the sense that they settled and paid whatever the agreement was?
Good faith settlement.
Well, actually, those policies were in force for a period of time. Mm-hmm. Let me just quickly tell you. There were three primary carriers: Liberty Mutual, Commercial Union, and the Hartford. Liberty Mutual had most of the years. For a period of time, Liberty Mutual actually administered the claims and was paying the claims as it went along. In 1999, there was a buyout settlement pursuant to which Chesterton bought out Liberty's policies for a lump sum, which was put into what is called the A.W. Chesterton Asbestos-Related Claims Trust. And since that time, Chesterton has administered the claims itself with the proceeds that are in this fund. And whenever Chesterton settles with an insurance company, the proceeds go into this fund. So to answer Justice Cordy's question, the court found that all those policies were exhausted. The analysis was never phrased in terms of was it through settlements or through payments.
That's the primary carrier level.
But it was proven that the amount of the limits was paid through payments of settlements and judgments, and in addition, there were settlement payments.
Well, in any
event,
we don't have to get into that.
We don't.
It's a stipulated fact that they were, quote, exhausted.
That's correct.
Okay.
Now we're at the excess layer.
So now we're at the excess layer. That was what this litigation involved, was all the carriers on that first layer of excess.
And is there another layer of excess as
well? There are, and again, if you look at this coverage chart, you'll be able to see it. They range between 1 and 7 layers, depending on the year that we're talking about.
Help me out on other courts, which may very well be in your brief, and I can't remember, but are there other courts that have sort of decided between this exhaustion in the sense that the judge used it and the pro rata settlement thing, or the settlement thing that you're talking about?
Not in this context,
so
Your Honor. And that is important.
There are
some cases that we cite, and there are some cases that the fund cites. They are all in a very different factual context. They are in the context of an uninsured motorist coverage, and there you have one claim and a policy, an uninsured motorist policy that has an insolvency provision, and therefore, and when the tortfeasor's insurer becomes insolvent, that uninsured motorist coverage comes into play, and it's a much easier situation to get your head around. And frankly, 175D, Section 9, has a specific provision that applies to that situation and creates a specific exhaustion requirement just for that situation and says the amount recoverable from the fund is to be reduced by the amount recovered, not by the total limits. And if the legislature had wanted to say the total limits, it could have.
So we're on new ground here.
Does it make a difference, as I understand, and we're asking you lots of questions, so don't panic with the red light, not yet anyway. Does it make a difference that, as I understand it, many, a significant number of the excess coverage carriers resisted the demands for, I mean, if we're looking at good faith settlement, does it make a difference that they would, as far as I can tell, denying coverage, correct?
It's interesting. It depends which ones we're talking about. They all do things a little differently. Most of, like Liberty, they all sent out letters essentially denying coverage, and at the same time, Liberty started defending the claims. What happens with...
Well, because there are real risks to a carrier if it isn't on very, very good grounds, right?
The issue here in this context is when we started this case in 1996, all of the primary legal issues that sort of govern what all the carriers' responsibilities were unresolved. And in fact, even to this day, this court in particular hasn't addressed most of the relevant issues, such as the allocation scheme, the trigger, other things along that line. And so what happens is when Chesterton files claims, the immediate reaction from all the excess carriers is, we don't have to pay because we have all these legal issues. For example, on the allocation versus pro rata, the big issue in the lower case, if the insurance companies had prevailed and the answer was it's pro rata, that would have shrunk. What that essentially means, if you have a claimant who was exposed, say, in 1940, and then he's diagnosed in the year 1995, every carrier on the risk gets their pro rata share of that, and the insurers would argue the insured has to pick up any uninsured years, and so their responsibilities for any given claim are drastically reduced. And so that's why these are not sort of typical situations like a car accident when it's very clear whether the coverage applies or not, which leads to another important point. When we're talking about the limits of these policies, the fund's argument assumes that what the limits are is a known issue, and that is far from the case.
Well, that's one of the I may not have stated the question so clearly, but if you're trying to look at a good faith settlement in that context, and it seems to me that that may be different than if you're looking at it in another context.
That's absolutely right, Your Honor. And I think we put one example in our brief, which involved, I'm sorry.
No, go ahead.
Which involved the Northbrook policy that was one of the other first layer policies. That had, like most of these, all these policies are a little different, and that had a couple of issues, such as it had an asbestosis exclusion. The insurer's position was, that means we don't owe Chesterton a single dime. Chesterton's position was, well, it may exclude certain asbestos-related diseases, but not all of them. That issue was not decided. If they won, the limits would be zero. If we won, the limits would be something else, but still not clear because that policy had what was called a stub period. Had 12 months and then a 13th month, and the issue was it the $20 million that appeared on the declarations page, or was it 20 plus 20, ascribing a full 20 to the 1 month, or was it some prorata of the 20 for the other month? So what are the limits on that? Is it 40, or is it 20 plus a 12th of 40, or is it 0?
But here in this case, we're talking about exhaustion as it applies, if I understand this correctly, as it applies to insurers at the same level as the fund, or as Midland.
No, not. No, what the fund's position is that Chesterton has to show that it is exhausted, and that the issue is what showing do we have to make, all the other policies, on all the other layers.
The layers up above it.
Even the ones that are issued above Midland, in different years before Midland or years after Midland, and at different layers of the excess structure.
And is that what the judge ruled? That all of the other layers have to be?
Essentially,
all the other layers?
Essentially, yes. And again, Your Honors have to understand the procedural context of this case in the sense that there were many, 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 many issues that were unresolved that had to be decided.
And I take it one of the problems with this type of a case is that when you do have exposure on the part of a plaintiff to a particular, or to the disease, asbestosis, you really have to look at the timeline of that particular person and then examine all the different policies that might have an interplay with respect to that timeline.
That's right. And one of the complicating factors is, as I said, there are literally hundreds of thousands of different individuals who have claimed to have been harmed by not only Chesterton's products, but all the other manufacturers or distributors of asbestos for the past 50 years.
And as you're driving down the road of this case, you have to look up and see what buildings, what insurance policies are hanging over each slice in time.
That's right. Although, because typically you just sort of move up through the layers because, and we make this distinction in our brief, insurance policies typically have a schedule, excess policies typically have a schedule of underlying insurance. And it says right in the policy, the policies listed on this schedule of underlying insurance must be paid, or in a lot of these policies even said, or the total amount of the declarations must be paid before we respond. That is exhaustion in the true insurance law sense of the word. What we're talking about is sort of this exhaustion that is specific to the fund, which in
the fund, I take it, the fund wants all of these claims to be settled as far as they could possibly go, and at the end of the line, if there are any claims left and any money owing, then it will pay money out. That's what it wants.
They actually want more than that. Chesterton wouldn't have a problem with that. The problem becomes if Chesterton has to prove that every dollar that appears on that coverage chart, which, as I explained to Your Honors before, may not be the real limits, but if every dollar that's identified there must be paid either by an insurance company or Chesterton before going to the fund, that is effectively going to extinguish all of Chesterton's rights against the fund, which is very significant because those policies were primary on the first umbrella layer, which are the most valuable excess policies for the following reason. Those policies typically pay for defense in one form or another. Mm-hmm. These particular policies had a duty to defend. Other policies will pay defense costs as part of the indemnity obligation.
And you want the fund to to stand in the shoes of Midland as if Midland were healthy?
No, but subject to the caps that the fund has in the statute. Under 175D, they have the $300,000 cap. So the way it would work is Chesterton would be able to go to the fund for two basic types of obligations. One, indemnity payments. And the indemnity payments would be if Chesterton settles with a claimant or a judgment is entered in favor of a claimant, then Chesterton should be able to go to the fund for indemnity, meaning to reimburse him for that amount, after it's sought these kinds of indemnity payments from the other carriers, and get up to $300,000 per claim. In addition, Chesterton should be able, with respect to the duty to defend, to go to the fund and get defense of any claim up to $300,000.
But within the cap set by the statute.
That's the cap, $300,000.
Yeah. Within the limits of the policy as well.
Within the limits of the policy. And once the limits of the policy have been paid out in chunks of $300,000 or less, then the fund's obligations will cease to exist.
Let me ask you this. I'm trying to look, this is a big layer cake. Let's take the layer, which is the first umbrella. You called it the first
umbrella excess layer.
Umbrella excess layer. Let's assume that we find that the judge is correct, that at least with respect to that layer, before you can go to the fund, you have to exhaust all of the other policies to their limits in that layer. Forget about the layers above it. Would that amount, the difference between what was paid and the limits, basically take the fund out of the picture as well? Or is it just when you calculate all the other layers above it that the fund is out of the picture?
That's a little bit of a complicated question for two reasons.
Yeah. Okay.
One, the only issue really involves Northbrook. I think it's Your Honor's question. The second issue involves the following. When Chesterton entered into settlement agreements with those insurance carriers,
Which ones now?
The ones that you're referring to.
Okay, in that
Your Honor.
layer, yeah.
On that layer, they all requested confidentiality provisions, which is a point that the fund brings up that says, we need to be able to see these settlement provisions if we're going to determine whether or not we think you settled in good faith. And frankly, Chesterton completely agrees with them, which is why when the fund filed a motion with the lower court seeking to have those policies turned over, settlement agreements turned over, we didn't object at all. The insurance companies objected, and the court denied the motion on the grounds that it doesn't matter what Chesterton settled for because I think that they have to pay the full limits of these policies, whatever it is.
Well, theoretically, on some of the claims, is it possible that the fund would have to pay some, but not the full $300,000 or whatever it is on a particular claim, and one of the other excess carriers in higher tiers would also have to make payments?
Not really, because of the structure that the fund is advocating, and which to a certain extent Chesterton agrees with on the indemnity side. If the fund only comes in to pay indemnity, meaning settlements and judgments, once all the other available, applicable solvent coverage is gone, then there won't be any other coverage to pay. The only exception to that, Your Honor, is the following. And again, it would help if we had the coverage chart. If we're talking about policies that sit in the same time frame as Midland, 1980 through 1983, there are policies that sit directly above them. Those policies, I don't believe that the fund even contends that those need to be paid before the fund responds, because those carriers will look at their policies and say, we have underlying schedules of insurance that say everything below us or the total limits have to be paid, and it hasn't, because, and we don't, in the state we don't have drop down. So in your hypothetical, there may be a situation, yes, where if there was, say, a situation where we're at the end of the line essentially, and there's one $5 million claim, the fund might pay $300. In that scenario, Chesterton then would be on the hook for the difference between that $300 and the limit of the Midland policy. And then the carriers sitting above the Midland policy would then have to respond to the extent there was more liability there.
Thank you, Mr. Gaynor.
I am 12 minutes over.
Way over time.
Way over.
So you will rest on your brief.
I would appreciate if Your Honors would look at the brief. Thank you.
Thank you. Mr. Deshay?
May it please the Court, Joseph Tansky. We're going to switch
I'm sorry.
our order, Your Honor. Mr. Deshane is going to address misrepresentation. Okay. I was going to address exhaustion, since the Court is focused on that, since we don't want to
That's fine.
skip around.
Go right ahead.
Okay. May it please the Court. Joseph Tansky, representing the Insolvency Fund. First, I want to correct a few things. Number one, this issue was addressed below by the trial court judge. Chesterton moved to amend the judgment when they weren't happy.
Oh, I understand that, and I think
Okay.
Justice Glaney...
Okay.
I looked at the order. I mean, it's a tough question, isn't it?
This question?
Yeah.
I don't think so.
And tell me,
Isn't the exhaust rule just a good, simple rule that'll work?
I think the exhaust rule is a good simple
your
rule
brother
that will
alluded
work.
to, we were talking about how are you going to prove good faith settlement. I said, well, there'll be litigation over that. Well, so maybe there will, maybe there won't. Then he says at the end, they wanted to look at the settlements that were made, confidentiality agreements. So now we got another case blooming. Can these confidentiality agreements be pierced to get at this? So I see litigation coming out of either rule.
Yeah. I think the rule the fund suggests, which is that where an insured does elect to settle for whatever we know, they elect to settle. We don't know if they took less than limits or not, but where they elect to settle for less than limits, that the fund is entitled to a credit equal to the full limits, which other courts around the country, the majority rule, have accepted that position.
in like circumstances? In mass tort circumstances?
Yes, in mass tort circumstances.
Oh, really?
What's the best case?
The Haseman case in Illinois, I think. I don't know if that was mass tort. But
because
this
it
is a
seems
fairly...
I'm just reading Judge McLaughlin's, is that everybody comes in and denies coverage. There may be very, very good reasons to deny coverage, very good reasons. And as you know, on a case-by-case basis, it's very hard I mean, you really have to litigate it in full. Now, in Massachusetts, we've made it very tough for insurers. You can't deny coverage and do nothing. I mean, then you are really proceeding at your risk. So now we say to them, you can deny coverage, you've got to go in and defend. And it seems to me that there's a very strong public policy, as long as it's good faith, and as Mr. Gaynor said, they want every dime. Why do they want every dime? It's because the fund has a limit. In other words, the fund is not an open checkbook, so they have every interest in getting every dime that they can at every layer.
Well, maybe, unless they won't need to get to the fund eventually. In fact, think of the facts of this case. You have layers and layers of coverage. We're talking about hundreds of millions of dollars of potential solvent coverage here. And under the trigger ruling in this case, all the excess policies are triggered at any time between first exposure and manifestation. And there's an all-sums ruling. That's the law of this case. So Chesterton has a right to seek, if there's, let's take a particular individual who had asbestosis. Any policy that was in effect during the period between exposure and manifestation is fully liable for that to compensate that victim. Chesterton can look to dozens of its policies right now to get coverage for that individual. They don't have to come to the fund. And what the fund is saying is go get your coverage from the solvent carriers.
No, I understand that, but you've, in a sense, made my point, which is Chesterton will do that, and it'll send out a notice to dozens of companies, and the dozens of companies will say, excuse me, tell me when, how, who, if.
I see what Your Honor is asking.
Right, and so you're getting this huge expenditure of resources.
Well, that's what they're doing anyway. I mean, these kinds of coverage cases, asbestosis, environmental, they result in coverage litigation. There are cases going on.
But they also result in settlements because sometimes it's infinitely in the party's interest to get the maximum coverage, and it may be, and to get the cases settled and so on. I mean, so to come in and say, well, you just must disregard good faith settlements.
We're not saying, Chesterton has said that when they do that, they lose coverage from the fund. That is not right.
You're saying
we get deferred till the end of the line.
Yeah.
To the end of the line, even over the excess carriers that are above your layer?
No, not those fellows, and we put that in our brief. People up above us aren't triggered. All we're saying is if there's another...
Give me a good example. We've got a $1 million
You've got a claim under the Midland policy, correct?
Good example is this. You have the fund here, and then you have in the first layer excess. Then you have a second layer excess policy in a different year. An individual is exposed prior to that other excess policy and has manifestation years from now. Chesterton can look to two sources there. One, they could look to the fund's excess policy, or they could look to that other excess policy because that other excess policy is in a year when that person was exposed, and there's an all-sums ruling, and Chesterton can get every dime from that other layer excess carrier. They don't have to they don't have to go to the fund. In fact, they've done that here. They've gone to their other excess carriers. And all we're saying is that when Chesterton can do that, they ought to be able to do it. They should not enter into an agreement with the excess carrier taking less money, because it's very easy for Chesterton to do that. They say, oh, we'll take less money, we'll get it from the fund. Who cares? In fact, if this Court will think back last year...
Can I just give you an arithmetic?
Yes.
What if a claim were settled for $1.5 million, and there was primary insurance for $1 million, the fund was in at $300,000, and then there was then there was two up above the fund. Let's actually talk about $1.4 million. So the primary carrier pays out $1 million. Right. You're saying that they should go to the higher level carrier for the next $200,000, and then you'll pay the second $200,000 rather than paying $300 and then look to them for $100.
No, they don't have to go to carriers that sit above us in the same policy year. I think that's what the Court's missing here. They don't have to go to carriers that sit above us in the same policy year. But if in the policy year before the fund's policy year, there's a carrier that is triggered, that would be required to respond because it provides coverage, they have to go to that policy.
And from your point of view, they have to get 100 cents on the dollar.
From the carrier. And
Is that at the same level? Is that like a
Well, they
second
wouldn't
level
have the-
excess? Or?
Your Honor, they wouldn't be able to go to the second layer or a higher layer unless the underlying carriers in that
All right.
policy year had been exhausted, because you
Okay.
can't...
Which they have
act-
been.
Pardon?
Which they have been.
Which they've done. What happens here is all the primary layers except the fund pays. All the solvent primary layer pays. Then we go to the next layer, and the fund says, okay, now you can go to your second layer carriers for all years except right above us. Go to those years. Once that happens, then they can go to the third excess layer. And we can say all those excess layers, except the ones directly above us in the same policy year, can pay. Go get them. They go get them. They keep doing that. In fact, eventually here, it could conceivably happen that Chesterton wouldn't even have to get any money from the fund, because they can get hundreds of millions of dollars from these other excess carriers. And that would be a wonderful result, and the Commonwealth's policyholders would never have to pay in that example. The only time that the fire arises is after they've gone through all of their other coverage that they can get, and now they come to the fund, and we say, well, you settled for less than some limits. You took $9 million instead of 10. You took $20 million on a $20 million policy, but you had a right to get defense. You should have gotten that too. And what we're saying in that instance is the fund gets a credit for what Chesterton gave up, and Chesterton has to eat that because they're the ones who made that decision.
You were about to say at some point, I think, that we decided a case last year.
I was going to remind Your Honors that, remember the cases that we had here, Premier and Safety?
Norfolk and Dedham?
Yes, Norfolk and Dedham, and there was another in Quain. And what was going on there is the fund said, hey, carriers should be exhausted. And the carriers denied coverage. They said, we don't know that there's no coverage. And so there was litigation over whether there was coverage or not. In one case, the court determined there was no coverage, so there was nothing to exhaust, and the fund had to pay. And in another case, the court said, well, the carrier is wrong. There is coverage, and therefore the fund doesn't have to pay. So the fact that you have a dispute with a carrier, a solvent carrier, over whether there's coverage or not, isn't the end of the day. It isn't the end of the world. What happens is you litigate that coverage issue, and there's either coverage or there is not. If there is coverage, then all of that coverage should pay, and I can't think of any good reason why they shouldn't. If there is no coverage, then the fund does have to pay. Chesterton is litigating it to the cows come home with its excess carriers over coverage. And frankly, if it pushes hard enough, as we know, in most occasions insurance companies end up paying. They have to, because there's very little outs for them nowadays. That's what Chesterton should do. It should go get its limits from its other solvent carriers. If they can't get them because there is no coverage, then there's no issue. The fund will pay, happily.
Mr. Tansky, I may remind you of that when you come back in about 9 years. I will remember.
Thank you, Your Honor. Now, I'm going to let Mr. DeShane comment on the other aspect of this case. Thank you, Your Honor.
Mr. DeShane? Which part of this will you happily pay?
Like two ships passing in the night, Your Honor, I'm going to address a couple of issues that Mr. Gaynor did not address, but are issues that were involved in our cross-appeal.
Sure.
The two issues that I would like to address are trigger. We've used the term trigger quite a bit today. And some issues related to the misrepresentation defense, which the fund raised, and we had a trial on, a 3-day bench trial before Judge McLaughlin, where he made extensive findings of fact and rulings of law afterwards. Let me take the trigger issue first. Trigger is a term of art which I think this Court is very familiar with from the Tufts case and the Gilbane case and other rulings that this Court has made. But the point I'd like to make about the trigger issue in this case is we're dealing with very different policy language that is markedly different than the policy language that you find in standard comprehensive general liability policies. And our contention is based on the policy language, and once again we're dealing with three policies, the Midland policies from 1981 through 1984. And that policy language requires that the occurrence take place during the policy period rather than the resulting harm or injury. And that's the distinction I'd like to draw. It's very, very different policy language. The occurrence is defined as an accident, happening, or event. And it is our contention that the trial court erred by holding that a bodily injury must occur during the policy period rather than an event, an accident or happening, which we contend is the inhalation of asbestos fibers. The second point I would like to make on trigger is, because this language is markedly different than the language this Court has dealt with in past cases, the resulting trigger has to be different. This Court has not dealt with this precise trigger language in any other previous case that I am aware of. However, we cited in our brief a case from New York, the In Re liquidation of Midland case, where the Court was dealing with the precise or very similar policy language requiring an accident happening or event during the policy period, an occurrence during the policy period. And the Court held three things based on that language. Number one, it requires a causative event, some sort of causative event during the policy period. Number two, that means it requires the exposure to asbestos fibers or the inhalation of asbestos fibers. And number three, it rejected the idea that exposure and residence, once the fibers are in the lung tissue and in the body tissue, that exposure and residence alone would constitute an occurrence. The Court held that it requires inhalation, that the exposure and residence is merely a progression or continuation of the previous injury.
Is that a Court of Appeals case? Is that their highest court?
It is not their highest court. It's their intermediate court. It was a trial court opinion, and then it was affirmed by the appellate division, Your Honor.
What is the consequence, in real practical terms, of adopting your interpretation of the trigger?
More coverage.
The consequence for the Midland policies, Your Honor, is they would have to show, a claimant would have to come in and show that they were actually exposed.
They inhaled
asbestos
during those years.
During those policy periods to a Chesterton product.
All right. And I take it that's unlikely, or?
Well, one thing I do not know, because we don't have these facts in the record, and so we do know that Chesterton sold asbestos products up through the year 2000. However, we know that their sales of asbestos products went down markedly in the 1970s and the 1980s, and therefore there could be, and I'm speculating here because we don't have any facts in the record, less exposure after the 1970s and 1980s when they stopped selling a lot of these products that contained asbestos, Your Honor. The trial court erred because it found that this policy language was somehow ambiguous, and the way that the trial court respectfully erred is that it found, first of all, it misplaced a modifier. The modifying language is during the policy period. And what the court did below was it said that that modifier did not necessarily modify only the immediately previous term, which was the occurrence, but it might have modified as well damages because of personal injury, which was a phrase that appears earlier. And our point on that is twofold. Number one, that ignores basic rules of grammar. If you have a modifying clause, you look to the immediate preceding term to see what it modifies. Secondly, it ignores an important placement of a comma. There is a comma after the words to which this policy applies. There's a comma there, and that comma is significant. It shows the drafter's intent that the phrase that appears afterwards, the modifying phrase during the policy period, only applies to the immediately preceding term, occurrence. And therefore, because the court basically revised the policy language and rewrote the terms, we contend that that was reversible error. The second issue I would like to discuss briefly is the issue of misrepresentation. As I mentioned, there was a 3-day bench trial. There were extensive findings of fact and rulings of law made by Judge McLaughlin. We believe that he made the correct ruling on the fourth policy year, the 1984 policy, based on the facts. However, we believe that he should have voided the 3 earlier policy years as well, based on those same set of facts. It is our contention that if you take an objective standard of what an objective, reasonable applicant would have done.
Sophisticated or not sophisticated?
I don't think sophistication really enters into it one way or the other, Your Honor. It's just looking at what a reasonable applicant would do given those set of facts. What would a reasonable applicant do? And it is our contention, if you look back in 1980, around the time period that Midland issued the first policy of insurance, Chesterton was on the receiving end of 4 asbestos lawsuits from Ohio claiming damages of $13.5 million. They immediately went into action. They hired outside counsel, they notified their primary carrier, and their outside counsel from Gas and Snow, Mr. Lane, told them, you should put everyone on notice, including the umbrella carrier. For whatever reason, they never told Midland about this. And our point on those three policies is that the facts really aren't different in 1980 than they were in 1983. They were facing multiple million-dollar claims alleging bodily injury because of asbestos exposure.
What precisely was the question? Was it question 17 that you say they did not answer properly?
Question 25.
Question 25, Your Honor. We know of no...
Not
We know-
14 or 17?
No, 25. We know of no other relevant
On
facts.
17, Your Honor, the trial judge held that there was a misrepresentation on 17 on the last policy period.
no,
But
I
with
know
regard
that.
to the three earlier policies,
Yeah.
only question 25.
But
Only
what about,
question 25.
Yes.
what about the other party's argument, though, that that question was so vague and ambiguous that it couldn't possibly, that their answer couldn't possibly constitute
Well,
misrepresentation?
that's why I
That-
asked whether you have to be even remotely sophisticated. No other relevant facts which might affect.
I respectfully disagree, because it's interesting in this case, Your Honor. If you look at the record,
The answer
they're
is-
claiming that this question is vague and ambiguous, and that is just incredible, because in January of 1984, in response to the very same questions, what did they do? They wrote a letter, and they unloaded all this information on Midland. They supplied a product analysis. They supplied a listing of 13 different asbestos lawsuits. They fessed up, and it's to the exact same questions, and
Now, if these three Midland policies, and we uphold them on the fourth, but we agree with you on the first three, all other issues disappear.
that is correct, Your Honor. The case goes away.
Well, not necessarily, well, okay.
Well, from our perspective,
We would have to, we would have to find him to be clearly erroneous.
no.
No?
No, Your Honor, I disagree with that, and that is
Oh.
because we argue in our brief.
Just accept
Now,
that he found to be...
on the fourth policy year, I agree with you, because all they're doing is attacking his findings of fact.
Okay.
And I agree
The
that's a
others-
clearly erroneous standard, and I think they're wrong on that.
Right. And the other
But
three, it's just a question
We're
of law.
arguing that, based on those facts, if you apply the correct legal standard, that we should win, because they should have disclosed it. A reasonable applicant would have disclosed these asbestos lawsuits. So we're arguing that it was an error of law. We are not challenging the
And
findings
this-
of
It would
fact.
be a misrepresentation that went to
That's-
the core of the policy.
That's correct, and
I have-
increase the risk of loss.
Innocent misrepresentation or negligent? Do we have to differentiate one from the other?
You do not, because the statute has two different prongs, as Your Honor knows. There's one prong requires an actual intent to deceive. The other prong, as long as the innocent or negligent misrepresentation
Affects
increases the risk of
risk.
loss to the carrier, that's enough to void the policy.
I understand precisely why you are trying to persuade me that it's a legal determination, but, whether a reasonable person would act in a particular kind of way strikes me as what we usually send to juries, and we usually don't send law to juries. This happens not to be a jury, but...
I understand what Your Honor is saying, but the other point we make in our brief is that when you read his opinion, Judge McLaughlin's opinion
Yeah.
clearly, reading between the lines, what he's really doing is he's crediting Chesterton's subjective belief that their products were safe, that these claims were meritless,
Yeah, it
that these
has-
gaskets didn't leak asbestos, and that they were wrongly sued and misplaced in this litigation. Now, I sat through that trial, and Mr. Hoyle, to this day, 2005, would testify that his products are absolutely safe, that his gaskets do not leak, and the seals are safe. However, it's belied by the fact that Chesterton has been sued in hundreds of thousands of
No, I
claims,
understand
and
that.
they've spent millions of dollars settling these claims.
It
And
has
so
to-
therefore, their subjective belief is
It has
is
to be a
erroneous.
reasonably objective person in their position, which requires some degree of sophistication. It's not just your ordinary person on the street.
I understand what Your Honor is saying, and the other point is that they went out and they hired counsel. Counsel told them to put the carriers on
This
notice.
favors you.
Yeah.
As sophisticated businessmen with lawyers, they're supposed to have a little better understanding of what this all means. The average guy in the street might say, well, my gaskets don't leak.
Mr. DeShane, I will only say this. Judge McLaughlin is a very good judge, and while if you read between the lines, I tend to read Judge McLaughlin on the lines. And so I'm not going to read between the lines with Judge McLaughlin. He's going to tell me what he found, what he determined. And I
Read the actual lines, Your Honor, because we also cite the actual lines.
I will do that.
I'll rest on my brief for
Thank
the
you,
rest of
Mr.
the
DeShane.
issues. Thank you.